So this is Jesse Rodriguez here, and I am on a call with attorney Ari Marcus. And Ari is a Fair Debt Collection Practices Act attorney, one of the best in the country. Am I correct?
That's correct,
If
Jess.
you don't mind me tooting your horn a little bit.
No, not at all.
So, basically, explain a little bit about what you do and what a Fair Debt Collection Practices Act attorney does.
Sure. So, we run a consumer advocacy law firm, which means we only represent consumers. And we don't represent any businesses. We represent the regular Joe Schmo working class guy. The Fair Debt Collection Practice Act field, we go after debt collectors who violate the Fair Debt Collection Practices Act. And what that means is it's a law that was enacted in 1977 to protect consumers against debt collectors. Debt collectors are well known for lying to consumers, harassing consumers, making false threats, including other violations. So the government felt a need to give the consumer a right to fight back. And that's what the Fair Debt Collection Practices Act does. It gives the consumer a private cause of action, which means it gives them a right to sue the debt collector and get compensated. The government understood that the violations and the debt collectors were running rampant, and there was no way that they could control their actions. So what they also did is they gave attorneys like myself a reason to sue them. And the reason being that the debt collector would now have to pay our fees if we're able to prevail. So
Perfect.
the way a case would work is a client would come to us. If we feel there's a violation, we would sue the debt collector, and our clients would be entitled to up to $1,000. Now, there's no way a attorney is going to sue a debt collector in federal court where it costs us around $500 to file if the most we're going to make is 1,000. So what the government did is they also put as part of the statute that I get to keep my hours, and if I win at the end of the case, the debt collector has to pay all my fees. That way my client, the consumer, never has a cost, doesn't cost them anything. I never charge them money for this kind of work, and they're able to fight back even on a $50 collection letter, on a $5,000 collection letter. It doesn't matter. If the debt collector is found to violate the law, my client's entitled to up to $1,000.
Awesome. And that leads into the next point that I wanted to cover. So you're saying that there is a way that people who are students of mine, even people that aren't, that students of mine can get an attorney to represent them when they feel like they've been, their rights have been violated by a debt collector without having to pay anything out of pocket.
That's exactly right. There's never a cost to any of my clients for this kind of work. We cover all expenses, we take on all the risk. And like I said, the reason being is the government wanted to make sure that consumers had the power not only to sue the debt collector, but to be able to hire an attorney to sue a debt collector if their rights were violated.
Awesome. So it makes it so that anyone can really hire an attorney if their rights have been violated. And let me tell you, I'm sure you see it all the time. I definitely see it all the time in my field. Debt collectors, a lot of them do whatever they want. And even me, like, you would think that you might do a Facebook search on somebody or something before they violate your rights. But even myself personally, I mean, still to this day, I have perfect credit right now, but I still have some debt collectors from the past. We're talking like 12, 15 years ago that are still um, contacting me.
That's right. Um, Getting debt collection notices shouldn't embarrass anyone because everyone gets debt collection notices. If you, let's say, were to go to the hospital because your wife's given birth or for any reason, it's easy to misplace a bill. It's easy to for something to lose track. If you move and a bill now doesn't get forwarded to you, it's easy for that to happen. A funny story is yesterday I was actually in court, and the defense counsel, so the attorney representing the collection agency, actually told me that he wanted to hire us to sue a different debt collector who was after him. I don't think it's going to go through at the end because he's going to get in trouble with his boss, but even he's getting debt collection notices. So it happens to everyone. Debt collectors, well, I'll put it this way. A big question I get is, if there's attorneys like myself out there suing them, why don't they just fix what they're doing? Why don't they just do the right thing? Why do they keep violating the law? And the reason being is because their job is to collect money. Their job is not to notify you of your rights. Their job is not to be nice to you. When a person gets hired by a collection agency, their job is to collect money. And if they're having a difficult time doing it, they're going to push the envelope and possibly break the law in order for them to get paid. And because there's so few attorneys like myself doing this kind of law, 99 out of 100 times they're going to get away with it. So it's our job and it's your job, Jesse, to get this out there to the consumer so they know that they have a right to hire an attorney, that it's not going to cost them anything, and that they will be compensated if their rights have been violated.
And that's great because that really explains a lot. I mean, it's happening literally every day where, you know, debt collectors are violating consumers' rights, but they didn't even know that they had rights. So they didn't know where to turn, which leads into my next question. What would you say are the top 3 violations that debt collectors are committing in your experience?
Well, it's a difficult question because the pendulum's always moving. There are certain violations where you'll see a lot of it for a couple months, and then they'll get sued a lot of times, and then they'll do a different violation. So it's constantly moving. Currently, right now, probably the big violation is when debt collectors are trying to collect on a debt that's past the statute of limitations. That means they're not able to sue on it anymore, but they're using language which makes it sound like it's a legally enforceable debt. So, for example, if they offer you a settlement on a debt that's too old, but they don't notify you that, hey, if you pay this or you pay part of it, the time to sue you will get restarted, that's a violation.
And that's
But
huge. That's
that's
huge.
a huge one. Yes, these are what they're called zombie debts or old debts where they're sold 3 or 4 or 5 times and you keep getting hit with the same debt over and over again. And you possibly paid it 2 or 3 times and didn't even realize. But as opposed to the 3 biggest violations, there's 3 types of violations we usually see. There's what's called a letter violation. So you get your typical collection letter. Now, every collection letter has to notify you of your rights to dispute a debt, every first letter. If they don't notify you of your rights, or if they overshadow your rights, so for example, you have 30 days to dispute a debt, 30 days from receipt of the notice. If, by example, they say in that same letter, if you don't pay in 10 days, we will sue you, now they're overshadowing your rights, or they're telling you. So on one hand, they're saying you have 30 days, but now they're only giving you 10 days to pay with a threat. So that's a typical letter violation. Um, there's the phone call violation. So you get called. That's where we see a lot of violations, a ton, because the callers are out there. They'll say whatever they want. They'll make false threats, threaten to sue you. They'll state it's on your credit report when it's not. They'll say anything.
They sure
And
will.
I teach my clients, you have to jot down the conversation. If you're in a state where you're allowed to record the phone calls, because it's very difficult to sue on a case where it's he said, she said. But if I have actual proof, we'll go after them. And then the third type of violation would be like a voicemail violation. So if they leave a voicemail on your phone, they have to notify you that they're calling from a debt collector. If they don't, that's a violation.
Oh, they
On the other
rarely
hand, if
ever
they
do
leave
that. They just say, this is an important business matter. Please call us back. And usually it's just an automated thing that they have dialing a bunch of voicemails.
That's right. Well, that would be a violation. The statute clearly says that they always have to state it's from a debt collector. On the other hand, if they leave a voicemail on, let's say, your cousin's phone or your mother's or whatever it is, and they state your name and it's called from a debt collector, now they're notifying a third party that you owe a debt. And that's also a violation. So it's important that all my clients and your students keep the voicemails, jot down the phone conversations, and keep all the letters so that if there's an issue, they can have an attorney review it.
Perfect. So I think that pretty much answered even my next question, which was how can they recognize when there is a violation? So that's awesome. I'm also going to create for my students kind of like a log where they can log when they got called, what happened during the conversation, and things like that. I'm going to edit this part out right now, what we're talking about right this second, but I'm
Sure.
also thinking of creating some type of website where they could, submit their log or submit the correspondence so that it could all be in one specific place for you to review.
Right.
Because I'm sure at this point, I know you're growing and you've partnered with somebody else, you know, that you're probably getting 100 or thousands of letters a day from people wanting to review their
Yes.
case.
We're bombarded with letters, which is a good thing. We have probably about 100 cases on queue right now. That means there are good cases that we haven't even got to filing yet, but we're trying to keep pace.
Awesome. So I think we're down to like 2 or 3 questions left. The next one that I have is, what should a consumer do if they're being harassed by a debt collector over the phone? What should they say to a debt collector when they're getting these harassing calls?
Okay, if you're getting harassing calls, again, it's important that you keep track of the phone call. If you can record it, legally allowed to record it. Um, you always have a right to tell a debt collector that you don't want to be called anymore, to cease all communications. But it would be important for you after you get off the phone to also put it in writing, send it certified. You no longer want any communications. Another option is to seek out a consumer advocacy attorney and have them write the letter for you. If you tell them you don't want to be called and put it in writing and they call you again, that's a violation of the Fair Debt Collection Practice Act, and you can go after them for that as well.
Awesome. And that's great because I'm actually teaching all of my students to do all of their communications with credit bureaus and debt collectors by certified mail. Keep it all in a file. I mean, have meticulous records. It's going to, they're going to have to change some of their habits, but
That's
you got to change your habits if you want to change your life.
that's right.
You know what I mean? So if a student knows that they are having their rights violated by a debt collector, how can they contact you? Do you want them to send the letter through me, or do you want them to contact you directly through your website? What do you think the best plan of action is if they believe that they're being violated?
Well, any way of getting the letters over to me is fine. If you want to go through Jesse, that's a great way to do it because Jesse's emails go to the top of my pile. When I see a Jesse email, I'll immediately open it up. But otherwise, you could call the office. My phone number is 732-695-3282, and you could ask for myself. Or you could email me at Ari, A-R-I, at Marcus Zellman, MarcusZellman.com, which is also on our website, marcuszellman.com. Any way of getting the letters over to me is fine. Once we get it, we'll have someone here, if not myself, review it and get back to you within a day or two to let you know what we think. Same with phone calls, voicemails. Any way of getting it over to us is great.
Yeah, and here's the deal. For anyone watching this, this is only for my advanced mastery students. Do not waste Ari's time. If you're wasting his time and he tells me, you're not going to be in good standing, guys. So don't waste his time. He's an attorney. He's going after debt collectors. He's not your personal assistant. So make sure if you do send him something, be short and concise and to the point and send all the paperwork. So that's my warning to the students because I don't want to hear from Ari that you guys are wasting his time. Time is the only thing we have in this world. And he wants to spend his time with his family, enjoying his family. So don't waste his time. You got to tell them that or they don't listen. Last question that I have on this is what's in it for the student if they do have a violation, you sue on behalf of the student and end up prevailing. What's in it for
Great,
them?
great question. So the statute entitles them to up to $1,000, which is great. It's always nice to make $1,000 for getting a debt collection letter. Um, there's some side benefits to suing a debt collector. So, although the statute doesn't guarantee it, so I can't guarantee it. In most cases, if we're able to settle it, we'll also get the trade line deleted, which is very important to most of my clients, and I know important to all of your clients. Trade line gets deleted, and if it's a debt collector that owns the debt, means someone that purchased it, like a Midland Credit Management or Portfolio Recovery Associates, they will, in almost all cases, also waive the debt. So we've had cases where people have gotten their $1,000 and then getting their $12,000 Amex bill waived on top of it. So getting $13,000 for getting a letter, which is great. So those are side benefits that I can't guarantee because the statute doesn't allow for it. But if we have a good case, we will always push for trade line deletion, and we will always try and push for debt waiver if the collection agency owns the debt. If they don't, we usually push that they give the debt back to the current creditor because we don't want that collection agency that we just sued still to come after you for the same debt. So as part of any settlement, we'll require that they give the debt back to the current creditor.
Absolutely. And the thing is, you know, the selling point isn't getting money. Really, for me and for my students, the selling point is being able to get the assistance of an attorney without paying anything out of pocket. If you get some money, great. If you didn't, you got the assistance of an attorney, and most likely there was some type of progress on that account. I mean, I very rarely have ever seen an account that I've ever sent over for one of my students to you or to any other FDCPA attorney that wasn't deleted from the credit report. So, you know, guys, don't go into this expecting the world. Don't go into this thinking it's going to be an extra paycheck. It's gonna, you know, it's going to help you, but most of all, you're going to have an attorney on your side. Not only that, you're going to build a relationship with these attorneys, and which is what we're doing here. So that was great information. Is there anything you want to add on that?
Well, I just want to add one quick point. I know it's a little bit off topic, but another side of the practice we handle, and the reason why I'm saying it here is because a lot of people who get debt collection letters also have an issue with robodialers, whether it be a debt collector or anyone else. If you're getting robodialed phone calls, that's also against the law, assuming that you never gave them prior consent.
And
So
that's the robo dialing means that someone's calling your phone, but it's not a human. So you'd hear a recorded message, or they'd leave a recorded message on your voicemail, correct?
correct. So if you have a recorded message or a robot on the other end or a computer, that's an easy way of determining it's a robodialer. It also could be a robodialer if they use a computer to call you, but then a live person gets on the phone when you pick up. So a lot of times you'll get a phone call, you'll answer, and there'll be like a 2-second pause, and then you'll hear a live person. That's a good indicator it's coming from a robodialer. And if you're getting those calls, that's something also you should keep track of because those calls you're entitled to 500 to 1500 per call. Now, if it's a debt collector for, let's just say, Amex, you probably gave your cell phone to Amex, which means they're allowed to call you. But once you tell them to stop over the phone, every call after that is a violation of the act. So that's something also your students should be aware of and they should keep track of if possible.
And if my students are following the instructions, they would already be on the do not call list and opted out from anything of that sort.
Right.
So that's great advice. Perfect.